we're going to talk about today. So today we are going to talk about how often young people come to folks like us to disclose their experience of abuse. We're going to talk about why or why not they're coming to disclose their abuse with us. We're going to talk about what do we do when they do, how do we safety plan, and what are some of their options under the law. So that can be something that we're thinking about when we're safety planning as well. And the goal when we move into next week's webinar is how do we actually work with young people and how can we prevent dating abuse from taking place in the first place. Okay, so just a brief recap of last week's webinar so we're all on the same page. For this webinar, I'm asking you to continue to remember that young people are more likely than adults to experience dating abuse. I'm asking you to keep in mind those 4 factors that we talked about. So trauma, limited relationship experience, their developmental stage, and their identity and background as we're working with young people, as we're thinking about how and why young people experience abuse, and as we safety plan with them. And we're talking about possibly helping them navigate systems. We're keeping those 4 factors in mind. We're also keeping in mind, what is dating abuse, right? So we talked about last week how dating abuse is when one partner in a relationship is engaging in a pattern of power and control. It does not need to be violent, and all forms of abuse can take place through technology. It's also important to keep in mind that we're really looking to see if one person's world is getting smaller, and that can help us to identify whether there's a pattern of that power and control. Okay, so let's move into talking a little bit about whether young people actually come to us. And unfortunately, the stats tell us that they don't, and just real life tells us that they don't. So I would love for you all to think about how often young people have come to you in your practice and disclosed experiences of abuse. Chances are you have not had as many young people come forward as the stats that we saw during webinar 1 would tell us there are out there, right? We know that less than 3% of young people will come to someone like us, so come to a counselor, to law enforcement, or to a teacher. 60% will tell a friend, so that perhaps is hopeful, and that's why joining us for next week's webinar where we talk about prevention, where we talk about how to have these conversations with young people is really important. So when they talk to that friend, hopefully that friend has the information that they need, but we know that they're not coming to us. And so I want you to take a moment and think through what it is that might prevent young people from coming to us. And I would ask that if you would list in the chat box some of the things that come to mind for you as barriers to young people seeking either you in particular, or your workplace in particular, or your line of work in particular, what prevents them from coming to you if you feel comfortable. If you don't, totally fine, I get that. But our hope is that during our 3rd webinar, we're going to circle back to some of these barriers and we're going to think through solutions. So I'm not looking to have us leave with all is lost, all we have are barriers, right? I want us to think through the barriers so that we can address the barriers. So if you list them in the chat box, I'm not going to really talk about the specific ones you're listing today. We're going to compile them and come back to you during the 3rd webinar with some information and thoughts as to how to go forward, okay? The ones that we have learned in our work are often the case, and maybe these will kind of spark some ideas for you all as you're typing your answers in the chat box, are, for one, a lot of the things we talked about related to those 4 factors, right? So the fact that young people might not be identifying something as dating abuse, clearly a barrier. The fact that young people and their developmental stage may mean that they're not really trusting us, and they may fear consequences, right? So that's one of the 4 factors. Also, identity and experience can definitely be a barrier to young people seeking out folks like us. If you're undocumented and you're not sure what happens if you come forward or call the police, are you going to call the police, right? If you're afraid that instead of helping you, you may end up removed from the country, that can be a barrier, right? Or if it means disclosing that you're in a same-sex relationship, that could be a barrier, right? So those 4 factors are really interlaced in lots of the barriers that we see coming from young people who don't disclose with us. It could also be that they love their partner, right? They love them and they're not at a point where they're okay with disclosing that experience of abuse. So that can be something that they're thinking about. Also commonly is if they have children together, right? So thinking about what it means in the greater picture if they were to come forward and talk about their experience of abuse. Now for today, we're really going to focus on the italicized barriers. So we're going to focus on unpredictable and inconsistent system responses. So not really knowing if I do call the police, if I do go to court, if I do go to the doctor, what will happen. We're going to talk about that. We're going to talk about the fear the parents will be informed, and I would add to that just the fear that another adult would be informed or caretaker will be informed. And finally, misconceptions about young people's rights. We'll talk about why it's so confusing. I mean, I'm a lawyer and still I have to kind of like double check things because the law is all over the place. And so we as adults providing support may give out incorrect information, inconsistent information. And if they're turning to their friends, like we saw 60% doing, their friends might not know what will happen if they come forward and what they're actually legally okay to do. So those are some of the barriers. We're going to circle back during the third webinar and talk about some of the fabulous ones that you came up with so we can think through our solutions, right? So how we can increase young people feeling comfortable disclosing their abuse to us. But for today, we're going to think about those barriers as we're thinking about how do we work with a young person and support them through safety planning. So for a second, I want you to think about what is a safety plan? What goes into a safety plan? And have you ever done a safety plan? Sometimes we've done them without actually naming them as that. And as I talk about this, I think some folks will actually be like, oh, I've done that. I've done a safety plan before. So really, a safety plan is a plan wherein we're trying to reduce risk and we're trying to increase protective factors. And by protective factors, I really mean things that that young survivor may already be doing to keep themselves safe, right? Ways they may be de-escalating things, supporting themselves emotionally, etc. A safety plan is not static. A safety plan is ever-changing. That's what can be so labor-intensive about a safety plan. It should be survivor-centered, and it should be determined by the survivor. Coming to a survivor and saying, hey, I came up with this safety plan. You're going to change your life in X, Y, and Z ways is not going to work, right? It has to actually make sense for their life. So we're working with that survivor to be like, here's an idea. Would that work with your life? Also, when we're safety planning, we're not assuming they're leaving. A lot of times we're safety planning for increased safety in that relationship. And we're thinking about escalation because whenever a young person is disclosing with someone else, whenever a young person is dealing with a system, the possibility of escalation escalates, right? Because the possibility of that abusive partner gaining wind of something. So all of a sudden, maybe the survivor responds to them in this way. Where did you get that skill from, right? Who have you been talking to? So we're thinking about escalation. And we're thinking about safety. We're thinking about safety everywhere. So we're thinking about safety internally, emotionally. We're thinking about safety when you're out in the community, whether it be in the neighborhood, in a grocery store, in a subway. We're thinking about safety at school, at home, and at work, right? So the different life circumstances that might come up for a young person. And when we're safety planning, we're really trying to think through what areas does the survivor have choice and control? Because if they don't have choice and control, it doesn't make sense to really try to shift that, right? We can figure out ways that they've kept themselves safe in areas they don't have choice and control, but there might not be able to be a shift in that arena. I already mentioned that it should be realistic, and also that it needs to be a plan around risks that are generated by the abusive partner, right? But also just life. So what do I mean by that? So life circumstances that increase risk could be the fact that they're a minor, so they may not be able to leave the school that they're in, right? Even though their abusive partner is there and knows that school. It could mean not being able to leave the apartment that they're in, even though the abusive partner lives down the hallway from them. It could mean that they don't have their own financial support, that they're supported by someone else, right? So we're taking those into consideration because otherwise it's not realistic. We're definitely removing judgment, and we're definitely taking away, well, if you don't follow this, I don't know that I can help you, right? So any hint of an ultimatum has to be removed from a safety plan. When I think about what a sign that what I'm doing with the relationship that I'm establishing with the client is actually working, unfortunately, one of those signs is whether they come back to me when bad things happen in the future, when they're in a future abusive relationship. Because I know that when they were in that relationship or prior relationship in the past, I must have worked with them in the way that was judgment-free and made them feel like they couldn't not come back to me, right? So unfortunately, we have to deal with that reality that things will not always go according to plan. You can go through a whole safety plan and they could decide in the moment to change that. And it is not, we want to make sure that they feel comfortable returning to us. When we're safety planning, we're thinking about legal systems, right? We're thinking about how can we get some more formal support, but that legal system is never the only thing we're doing to safety plan. We're always safety planning alongside, and we're always thinking about evidence, because evidence is not only for legal systems, it's also for trying to figure out what is going on and when do they do X, Y, and Z. And we'll talk about that in 2 slides from now. We'll talk about what evidence is and why that actually matters. So going back to what I said before, we're not presuming that they're leaving a relationship. What this stat shows us that young people who were experiencing dating abuse, about half of them also reported that they were still in their relationship because they feared physical harm if they tried to get out of it. So people stay for a number of reasons, and one of those reasons is that it could be less safe if they were to leave that relationship. So we're really keeping that in mind. Okay, so we talked about what a safety plan is. Let's talk about how the law fits into a safety plan, and why we're even talking about the law. So I mentioned before, the law is super confusing. It is inconsistent. We as service providers often don't know what the law is, and young people don't know what the law is. And actually, the people enforcing the law may not know what the law is. So know that going into it. To highlight how confusing and inconsistent it is, it could be that in New York State, sexual consent is technically 17, but it's more confusing. It actually depends on the age gap between the two partners. You can get child support up to age 21. You can enter a domestic violence shelter at age 16. You have to have the young person's consent if they're going to be adopted, if they're ages 14 and up. You can be on the hook for student loans from 16 and up and be an organ donor, but for healthcare, you have to be a mature minor. So you can see it's already all over the place, right? So these laws are simply not simple. And so we need to be thinking about it and doing our research when we're talking to young people about accessing systems as a method for trying to figure out how to increase safety. So the decision whether to access a legal system is a big decision. I said before, it should not be the only form of safety planning. Safety planning should run concurrently with any legal system. Entering a legal system could cause things to escalate, so that's huge, because in most legal systems, the abusive partner has to know that you're in the system, right? They're going to find out. So just to be thinking about that reality when you're accessing a system. It's really important that you not sugarcoat what the reality is. There's a human element that comes into play whenever someone's going to a healthcare provider, going to a judge, going to the police. That really is out of our control and leads to a certain level of unpredictability. Know that you can engage in multiple systems. So one doesn't negate another. I've had a number of clients that were in the family court system, they were in the criminal justice system, they were seeking health care, they may have been in shelter, right? So a number of different systems all at once. But you can also engage in no systems. And day one, worked with a client that was super high risk, was physically and sexually abused regularly. And that young person decided not to access any systems. and made a decision that to access them would actually be less safe for them. So the decision to not engage in systems is a real decision. Know that it's really going to depend on what they're trying to do, but it's also going to depend on the abusive partner's personality. Because for some folks, going to the police is not going to make the abusive partner stop. And so why go through all that if that's not going to be the case? Prepare for pushback. So I have accompanied clients to court as their lawyer, and I've been told they cannot file because of their age, that their parent must file for them. That is incorrect. But there was pushback, even though I was there with the client, and actually the parent was there too. My client just wanted the petition in their name. So just be aware there will likely be pushback, and that's why the advocacy that we talked about so much during webinar 1 and keeping those 4 factors in mind is key, is definitely key. Know that just because something happens on a Tuesday doesn't mean that you have to go to court or a legal system on a Tuesday. So it doesn't have to be contemporaneous. That's why evidence is really key, because even if you decide not to go today, you still made sure that you got whatever proof you could while it was happening. Because we know, particularly with tech, it just goes away. It can be deleted. And so it's really hard to get back. So you don't need to make the decision right now. I've had clients who wait a year to make a decision to go to court. And they're able to speak about instances from that year, from the year before that. So know that it doesn't always have to be this rush to the courthouse. Evidence. I know folks think of that as like a very legal thing, but actually the chances of a client coming to me are more likely if they're encountering one of you that knows what they're doing, that identified dating abuse, that was safety planning with them, and talk to them about evidence, right? So that by the time they're with me, the evidence is not deleted. The evidence is still going on. Evidence is also not just for a legal system. Evidence is to help us figure out what on earth is going on, right? What are these patterns of behavior? And so I really encourage folks that if they're working with a survivor and you're safety planning with them, have them keep a log. Don't keep a log somewhere that the abusive partner can see or read or access, right? So if they know their email password, if they get into their phone regularly, those are not places to keep a log. Maybe they keep the log at your office. We keep a log of the partner's activities. And I encourage folks to keep it with the date, the time, what happened, where was it, and what were they feeling, right? So not only do they have kind of like, oh, I see that after they go to visit their mom, I see things escalate, right? So we're going to talk about safety planning around that reality. Maybe you won't be home on that day, right? Or I see that the day that they're paid, then they drink and then the violence escalates, right? So we're starting to try to see a pattern of behavior. For evidence, also just maintaining everything. So have the young person take screenshots of their text message, of their direct messages, of their emails. We'll talk about this during our October webinars about tech abuse. We'll talk about it in greater detail. But it's really important that the survivor be the one to take the screenshot and that they maintain it somewhere. And so keeping that with you, again, could be really helpful so that the abusive partner cannot see the information. Also, evidence could be damaged belongings. So last time, I believe I mentioned that a lot of times my clients' partners will buy them something and then destroy that something. So either keeping that damaged something, right, or taking pictures of that damaged something can help keep evidence. I know that evidence doesn't have to be perfect. It just supports something. It just supports the conclusion that this happened. If you don't have evidence, simply the survivor's recollection is evidence enough, right? That's a form of evidence. So don't get bogged down in like law and ordering it and hearsay and all that stuff. Just keep what you can, and as much as you can, have the survivor keep the information and collect the information. Okay. So let's talk a little bit about some of the laws around young people. And one of the things I want to talk about first, because it really branches out into all that we do, into us as service providers, into especially if we work for community-based organizations, or we are social workers working with young people, or we're trying to refer someone to an organization and we're afraid of who they might tell. it's really important to be informed about mandated reporting and what it actually requires. So a lot of times we think of mandated reporting as I have to call Child Protective Services if some kind of abuse or neglect happened to someone under 18. That is not what mandated reporting requires. So mandated reporting is required for certain folks. I'm a lawyer, so I'm exempt from that. But for certain folks, social workers, teachers, etc., if it's the parent or person acting as the parent that is abusing or neglecting the young person. Generally, when it's dating abuse and sexual assault by a romantic partner, it is not a mandated reporting issue. If you call Child Protective Services, it could result in a criminal case starting instead of a child protective case if they can't take it. The only times when I tend to find that a mandated reporting issue is activated is one, if the couple has a child in common and the violence occurred in front of the child in common, that could be a mandated reporting issue. So it's important to inform the survivor of that you may have to call folks about it. Or if the survivor or abusive partner's parent observed, knew of the violence, and did nothing. That could possibly be a mandated reporting issue. But generally, dating abuse and sexual assault by a dating partner is not a mandated reporting issue. So it's really important that we as service providers are following the law, and also that we're advocating with other service providers who, because maybe they want to share the responsibility. I get that. You want to sleep at night, so you want to call it in just in case. But actually can increase violence not only between the survivor and the abusive partner, but also within just the larger family. So it could maybe not be safe at home for the survivor as well, right? And now Child Protective Services is in the home. So it's really important to be thinking about mandated reporting when we're talking about young people's legal rights to access, because it really activates who are you going to tell? Who do you have to tell? And so we'll talk about this during webinar 3, but that's why it's so important when you're first meeting with a young person to tell them who you have to tell when you have to tell, right? My name is Caitlin. I'm a lawyer, which means that what you say to me is confidential, and I need to get your permission if I'm going to share it with someone else. So having a similar first line to your meeting. So when we're thinking about dating abuse and safety planning and ways to increase protection, one of the most frequent areas that young people or folks who are survivors will think about accessing are areas where they can get an order of protection. And so usually in New York State, that would be in family court or that would be through criminal court. So we're going to talk a little bit about what that is. In my work as a lawyer, I did a lot of orders of protection in family court, but I also did a lot of advocacy when there was a criminal case as well. And so I would encourage you you can advocate within either, if they have a lawyer in family court, if with police or prosecutors in criminal. So what is an order of protection? You'll also hear it maybe called a restraining order, right? Or a stay-away order. But really, an order of protection, it's a piece of paper that is signed and ordered by a judge that requires a partner to do or not do certain things against the survivor, right? The survivor cannot break an order of protection. That's really important to know. I've had clients be told by police officers that they violated an order of protection where they were the protected person. That's not possible. So know that when you're advocating. And generally the things that will be in an order of protection are things like the abusive partner is required to stay away from the survivor, stay away from the survivor's home, school, work, that they not contact the survivor, whether it be by phone, text, direct message, social media, that they not commit a crime against them. I know that seems very straightforward, but they will include that sometimes as like a, hey, reminder, don't commit a crime. It may require that the abusive partner move out. That's called an exclusion order. Also in family court, it tends to be a little more flexible. So if there is non-consensual pornography involved, it may also include that you are to delete any and all sexual photos, that you are not to disseminate sexual photos. It can also require that third parties not contact the survivor on the abusive partner's behalf as well. so that they're not having an intermediary, if you will, reach out. So one of the areas that you typically get an order of protection is family court. And so I mentioned that family court was usually my arena. But what would happen is the survivor would go to family court, ask to file a petition. It's called a family offense petition. They're able to do so without a parent present. There's no age listed in law, although you will find a lot of clerks and some judges saying you have to be 18. That is not listed in law. Know that a clerk cannot tell someone that they cannot file something. Clerks are required to file whatever the person is there to file, and it's up to the judge to determine whether they have the legal right to be there. So when you get pushback from a clerk, ask for a supervisor. If you know that judges in your area tend to say that you need a parent present or you need to be 18, prepare your advocacy. You're going to have to prepare that young person for this. You're going to have to prepare to see who locally is doing work around this particular issue, because young people have a right to be in family court. As of 2008, folks who are in an intimate relationship can be in family court and ask for protection. One of the things about family court that can be rough is that you have to state that you're in a relationship, right? So you have to state that you're dating. So for someone who maybe doesn't want to state that, I've had clients who are willing to go to criminal court because they don't have to say they're dating, but don't want to go to family court because their family would find out that they're dating. It can be rough because the survivor has to go to court and has to go to every court date, and has to make sure the partner knows about the case, and the partner will likely be in the courtroom. So those can be rough things. However, the positives are that they largely determine when it begins, when it ends. They have a right to a lawyer who can keep things private and advocate for them. And it also doesn't require that they involve the police or that folks be arrested. And so that can be a selling point, particularly maybe if their partner is undocumented. And so while they want the violence to stop, they don't want them to be incarcerated and possibly removed. So know that that can be one of the benefits. Sometimes it does result in arrest. I'm not going to go into great detail, but it doesn't require police involvement or an arrest. And it can be a good place to be if there are children involved, because then you can talk about custody, visitation, and you can talk about the violence in the relationship as well, all at once. So that's one path you can go. You'd have to go to family court, village courts. I know upstate, not everyone is a lawyer that is seeing these cases. In New York City, they're a lawyer or judge. And so it's just good to know, kind of get a lay of the land before you're taking a client through that process. The other option for an order of protection is usually the criminal process. And this typically begins with a call to the police or a police report. And so this kind of case can begin without the young person even knowing that it was going to begin. It could be that their parent or guardian called the police. It could be that a neighbor called the police. And so all of a sudden this criminal case began that can have an order of protection in it, even if they don't want to have an order of protection, even if maybe they're living with their partner, there can be that order of protection. Oftentimes the partner is arrested, so to know that. Sometimes both partners are arrested, particularly if the person who's experiencing the abuse is male expressing or a same-sex relationship. We're more often seeing dual arrests in those kinds of cases. So be aware of that. Or if there was any self-defense, there can be an arrest. The criminal process is largely run through the prosecutor, right? Law and order, the district attorney. So the district attorney is representing the state and files against the abusive partner. That can be great for a survivor who wants to kind of do hands off, like, see, I didn't file it. It's not my case. I can't stop it. They wouldn't have to go to every court date, but they might have to testify. But it can be really frustrating for a person who doesn't want the order of protection and doesn't want the criminal case to begin. And so I really suggest advocating. I typically reach out to the district attorney and I let them know what my client wants. And sometimes they're amenable to that. And because the idea is if you have an order of protection, it's only as effective as whether that survivor is going to say that the person violated or call the police when they violate, right? Enforcement power rests with the survivor. So if the survivor doesn't want an order of protection, they're probably not going to say they violated it, right? They're probably not going to call the police. So it's just this paper tiger. It's important to know at the criminal process that the district attorney is not their lawyer, so they don't keep things private. And that when the young person is a CW, that's a complaining witness, that the parents don't have a right to be present during that interview. So that's really important to note. A lot of times parents will push to be there. So those are some of the processes that you'll see that are more formal for an order of protection. And let's move into talking a little bit. I see folks even talking about Title IX on the chat box, although I'm not reading it intensively. Let's talk about some more informal ways that you can kind of have an order of protection without the power for police that are not campus police to enforce it. So Title IX is something to be thinking about when you're working with a young person, and that young person is in school, whether it's K through 12 or college. As long as that school receives federal funding, then they are subject to Title IX. And under Title IX, the school is responsible for preventing a hostile environment that disrupts the young person's education. So if they know that sexual harassment, sexual assault, dating abuse is happening on school grounds within their school community, they have a responsibility to prevent that from continuing. They also are responsible for addressing misconduct when it occurs. So when they know of an incident, they're responsible for investigating and addressing misconduct when it does occur. Now, when you're working with a young person who's in school, whether the abusive partner is in school as well or not, although that will change exactly what kind of accommodations you're looking for, it's really important to have Title IX as part of your safety plan. And remember, we talked about life circumstances that they can control and life circumstances that they can't. Well, it's really important to sometimes involve a school, because a young person is not going to be able to control their abusive partner's class schedule, right? If they're in the same class together, it's not just going to take the young person writing up a safety plan that says that I won't be in the class with them. It's going to require the school to help support and perhaps intervene and change schedules to do so, right? So that's why it's really important that you're doing things concurrently and not assuming that one element is enough. So some things you could ask for if there is dating abuse are a lot of times it impacts whether you go to school, whether you turn in assignments, the level of your assignments, whether you take tests. So you can ask for things like counseling to support you for whatever trauma is the result of that dating abuse, and tutoring, right? You might be behind because of the experience of abuse. You can ask for accommodations. You can ask that there be a changed course schedule. You can ask for things like moving your locker. So if your locker is right by your abusive partner or on the same hallway, you can ask to move that. You can ask to maybe have the abusive partner come to school a little bit earlier, leave a little bit later, so you're not crossing paths as you're coming to and from school. You can ask that you be removed from a class that you're in with the abusive partner, so things like that. You can also ask for assistance. So I know that I have to have made this many classes to pass a course, but this is why I haven't made those classes. So you can ask for support around that. You can ask for some security in areas where incidents happened before. So a lot of times we hear about stairwells being a place that it happens on school grounds. You can ask for no contact orders. So that was something talked about in the chat box. So instead of going to family court and getting a judge to sign an order that's legally binding that the police have to enforce, you can get what's called a no contact order that requires the abusive partner and the survivor to avoid contact. And it can be constructed however it looks. So it can be that if the abusive partner sees the survivor in a hallway, then they are expected to remove themselves from the situation. Or that they not use the same bathroom, that this person used this bathroom, this person used this bathroom. So it can kind of lay out what the expected conduct will be. It can also include and ask for a school safety transfer. However, I know in New York City, it's most often the survivor that's transferred. And so to really think through this option when you're thinking about this as a possible accommodation, because the survivor has likely lost a lot already, and asking them to possibly change schools or campuses means changing staff, means changing friends, means changing just their status quo. And so to be careful about when there's a push by the school to do a school safety transfer rather than deal with the situation on hand. So that's what Title IX can help you to do. Know that Day One has an attorney who focuses specifically on Title IX. So if there's ever support needed for a young person that you're working with, or you're trying to work with a school and they're not really supporting, feel free to reach out to Day One and they can connect you to her. Okay, so going on with some of the legal options for young people. So we talked about school. Also, one thing that may come up when you're working with a young person, safety planning and trying to figure out kind of contingency plans, are planning for basic needs. So by that, I mean housing and financial support. And I find thinking about this particularly important for both LGBTQ young people as well as young people who live with or are supported by their partner. Why is it particularly important for LGBTQ young people? Because oftentimes when relationship violence comes to a head and family finds out that that person is in a same-sex relationship or about their gender identity, they're often kicked out. So coming up with a plan for housing and how that young person is going to support themselves might be very key, because it might not be even the partner that's doing X, Y, and Z. It could be that family is not providing that support. So some things to keep in mind. So it's important to sometimes assert that someone's a domestic violence victim when it comes to housing, because you can be eligible for emergency shelter if your age is 16 and up. Know that some shelter workers think it's 18 and up, so be prepared to advocate. Also, for some domestic violence priority when it comes to public housing, that can make you be a little bit higher up on the waiting list. In terms of financial support, young people who don't have support from their families and are ages 16 and up can assert that they're emancipated and that they should get public benefits in their own name. So that's something to be thinking about. Those young people can also assert that they're independent students if they're in college and maybe their parent no longer will provide them their tax returns for their FAFSA because they found out about their relationship. So know that they can be asserting that. Also, alternatively, the young person could ask for support from their parents up until age 21. So a young person can't say they're emancipated and ask for child support. They have to pick one, but know that they have that option. And if you're in New York City, youth shelters are now up to age 24, which is great. So that can be an option. It's not domestic violence specific, but it is an option for housing. So the last area I want to talk about with the law before we start wrapping up what a safety plan is and get to some of the questions are that sometimes young people may want to seek medical services, and so it's important to understand what they can consent to and whether things are confidential, because whether they're the one consenting determines whether it's confidential. So we're going to talk about really 3 different categories of young people and services. So the first category is when a young person is pregnant, parenting, emancipated, so that's without the financial support of their parent, married, or in the armed services. They can consent to any and all medical services, just as if they're an adult ages 18 and up, okay? So that's the first group. The second group is when a young person qualifies as a mature minor. This is determined by the service provider. That's why advocacy is really key from us, because we're advocating for them to be seen as a mature minor. Because as we remember, though their brains are still developing, they can still make really powerful decisions on their own with extra support. So we're advocating, so those who are mature minors, and I would describe a mature minor as a young person who can weigh the pros and cons, who can make an informed, voluntary, and considered judgment about whatever care they're accessing. And so a mature minor can consent to and therefore control confidentiality for reproductive health services, for post-sexual assault care, and for non-medical substance abuse services. But it's important, the practitioner basically has to put in their medical notes how they came to the determination that they're a mature minor. So that's really what the advocacy is around, should any issues be brought up. The third group of young people, when we're thinking about healthcare, or rather the third group of services, is requiring that a young person be both a mature minor and that they fulfill one of these pluses. So they have to either argue that involving their parent would be detrimental to their treatment, or it has to be that the parent refused consent and treatment, and that refused consent to that treatment, and that treatment would be in the young person's best interest. So it's a mature minor plus analysis for these services. And actually, Day One navigates providing mental health counseling by saying, most generally, this doesn't apply necessarily to every case, but that if they're a mature minor, and letting their parent be involved and know would be detrimental to their course of treatment, that they would stop coming, that perhaps they wouldn't provide the same level of candor if they were to have a parent involved in the process. And so for the mature minor plus, if you can show those two prongs, then a young person can consent to and control confidentiality for mental health counseling, outpatient and inpatient substance abuse services, and general health care. So know that really it's just about making sure that you're advocating for them to be considered a mature minor and this plus analysis, and asking that the service provider do just that, and they can note it in their clinical notes, right? That this is how I determined that this person can proceed without their parent being present. Let's talk a little bit more about post-sexual assault care. So as you may remember, that just requires that the young person be a mature minor, right, to be able to consent to and determine confidentiality for their post-sexual assault care. When we think about post-sexual assault care, it usually is a forensic rape exam. So it's listed here as an FRE. And so they're able to go to a hospital. We recommend looking for safe centers in their area. You can Google so that they're well-equipped and knowledgeable about how to deal with folks who just experienced sexual assault. So they have the option to go for a forensic rape exam. And with that forensic rape exam, they can get emergency contraception and they can get HIV and STI prevention. For the most part, if they're a mature minor, then they control whether it's confidential. There's some exceptions. So if they come in and they have an injury from a gun or knife, or they have a high-level burn, or it's someone who was a parent or caretaker who sexually assaulted them, then other folks might need to be involved. But for the most part, a young person who goes to a hospital for post-sexual assault care controls confidentiality. They also control whether that kit goes to the police. So they have to consent to the kit, the forensic rape exam, and they also have to consent to whether it goes to the police. So keep that in mind. It's also important to think about the time frame that's recommended for going to the hospital to seek these services. So for HIV STI prevention to be most effective, they generally say 72 hours. For emergency contraception, they generally say you should do it within 42 hours. And for the most effective forensic rape exam, they say 96 hours, recommending things like not showering, right? Another thing to keep in mind is that while this forensic rape exam will give them a limited supply of HIV STI prevention, they're only going to give them 7 days. So, and the recommended dosage is 28 days. So getting up to the 28 days if they're under 18 may be more complicated and may require insurance or parent involvement. And so I highly recommend reaching out to Day One if that's the case, so that we can work around that and try to support the young person as we go through that. Okay, so let's start wrapping up safety planning, and then we're going to address some questions. So what are some considerations? If you're staying, you want to talk to the young person about some enclosed areas, right? Bathroom, kitchen. We say places that have no exit can be most dangerous. The stairwell where there's no way to exit. Also think about what you're giving them, right? Reconsider business cards. Ask them if it's safe to call, text, email, send a letter, because you don't know what that partner can see and what they can access. Think about using a blocked number when you're calling or texting. Also talk to them about having a code word, right? So if they're trying to let a friend know that they're in danger or they're safe, have a code word for that. And talk about the role of technology and what their partner actually has access to. You want to work with them to try to compile evidence, identification, keys, finances, all of that. So if they ever need to go, they could do so more easily. And to have a phone that's charged with them on at all times if they can. With all safety planning, right? What are the protective factors? What are the risk factors? What have they been doing thus far to keep themselves safe? And what are the patterns and how can they work on de-escalating things? Whenever they start to work with someone, things can escalate, right? Because things might change, even subtleties. So we're talking through escalation and how they're keeping themselves safe, right? Emotionally as well. Because being in an abusive relationship can feel overwhelming. So what can they do to ensure that their emotional health is something that they can prioritize? We're going to talk to them about evidence, a reminder, thinking about the fact their partner might be able to see whatever they compile, a trusted friend, us. We might be the source of where the evidence is. And also think about the fact that if they're sexually assaulted while in a relationship, they can still do the forensic rape exam, right? It doesn't automatically start a criminal case or a police report, and it's kept for years. So they have some time to decide, but evidence leaves, right? So thinking about that time frame for them to be doing the forensic rape exam. So those are some things they're thinking about they're saying. If they're leaving, you're going to discuss a lot of the same things, but you're going to talk to them about if they're planning to leave, not sharing that plan with a ton of people, right? Discuss who they're trusted, who they trust. Again, having their phone on them and charged at all times. Code words, a reminder that tech abuse does not leave when someone leaves a relationship. It continues. So again, come to the October webinars, but it continues, right? If they had access to the email then they probably have access to email now. And we know that when you leave a relationship, it can be the most dangerous time. So we're thinking through escalation and using tech to figure out if things are escalating, right? I've worked with folks where their partner used to post a ton, post their mood essentially for the day, which was really helpful because we could safety plan around it. Talk to them about their routines, what their partner knows, and adjusting those routines. Talk about children. If that child is moving between two households, they may be carrying information or tech or location between two households. Talk about housing and how they can support themselves, and also whether they should be informing folks at the different places that they will be. It can be hard to think about sharing this information, but if that partner shows up at work, it may be helpful to have one person know that there's something going on, right? So to sum up, just a reminder, young people rarely come to us, and so I consider it such a privilege when they do. And I am making sure that I'm working with them and supporting their decision making as much as I can. Since, again, rare occasion and a privilege. It's okay to say you don't know. Do your research, get back to them. You don't have to know everything. Tell them if you're going to have to tell someone else. Involve them in that telling if you can. Legal path should be a supplement, not a fix-all. Take that extra time with them and encourage others to do the same. And really be upfront with them. Don't sugarcoat, be transparent, so that they really know what they're getting into. All right, folks, we have some questions. Let's see if we can answer them. If for those that we're not able to get to, we will try to answer during the next webinar, or we can always respond by email as well. Okay, the first one is locally judges have started to make orders of protection mutual and issue them against both parties. Is that happening in other places in New York? How do you advocate around this? It's, as far as I know, not happening too much in New York City. You advocate around this by getting judges to understand that domestic violence is not a mutual and two-way street, by helping them to understand the goal of an order of protection, doing domestic violence trainings. Really, I think they're just trying to make their life easier, but that's not what an order of protection is about. But I would love folks to respond in the chat box if they're finding that that is happening and if they have any tools for advocacy. We have a question about whether hospitals generally follow this confidentiality process. It's the law, but is it generally in practice? I mean, HIPAA is supposed to be a powerful thing. However, we know that when it comes to working with young people, people really like to involve lots of folks. They like to protect young people, and they think that protecting young people means involving a lot of folks, involving police, involving parents. My experience has been that in New York City, there's some really well-trained, safe centers, and they're generally trained by day one as well. And so they tend to have a better sense of how to work with young people because we train them on working with young people. But I'm not sure how this is happening across the state, but it's a big deal if they're not maintaining confidentiality. So if folks are hearing about it, let us know. But my experience is, yes, that if I'm doing the requisite advocacy to ensure that the young person is seen as a mature minor, then confidentiality must and should follow. And here are some answers that folks have also shared. That they've known hospital offices to call state central registry, so that's Child Protective Services, with allegations of inadequate guardianship. Yeah, that's something that comes up when they have a young person come in with an dating abuse information with the idea that the parent should have known or must have known, which is really unfortunate because we know that that is not the case, that a lot of parents don't even think of their kids as dating, let alone thinking of there being dating abuse or sexual assault in the relationship. So that's really, really unfortunate, but not surprising because, like I said before, folks really like to share the burden. They like to not have everything on their shoulders. And so they involve as many folks as they possibly can. It's likely that once it got to state central registry, though, that it became a law enforcement case, that it was no longer, it wasn't accepted by Child Protective Services. Not only usually because of older youth are not as accepted, but also when it just doesn't follow what qualifies as a mandated reporting issue. If the parent did know about it, then yes, it could be inadequate guardianship, and so it could be an instance of neglect that could be indicated. Also, an answer to the question regarding whether hospitals are following confidentiality. Hospitals also disclose information by coercing or requiring disclosure of insurance information, then pursuing payment through teen parents. So that's an excellent point. So when you get a forensic rape exam, that is reimbursed by the Office for Victim Services. So that's a state agency. They will reimburse for the actual forensic rape exam, and they will reimburse for those 7 days of HIV, STI prevention. However, if you want the additional 21 days, and if you want sexual assault counseling, or if you have injuries that are going to need to be treated beyond the exam, then you can ask OVS to cover that, but you have to have the parent or guardian ask for that. And it would have to first be billed to the insurance, and the insurance has to say no before OVS will cover that. So it's kind of the additional layer that can come up when you have sexual assault. And yes, sometimes hospitals and any service provider may essentially make a young person feel like they don't have options. And that if they don't do this, then they're going to talk to this person, or they won't do the exam for them. So young people are very susceptible to that kind of coercion. So that's why having folks like you all be part of the process, advocacy from A to Z. I also recommend getting a lay of the land before you send a young person anywhere. I reach out to service providers and say, hey, here's a hypothetical situation. How would you handle this? I'm sending them with an intern. I'm sending them with an advocate. I'm going if I can. I'm making the calls. I'm having them meet with someone that I know personally. So as much as you can do those things beforehand, the better, because you want the young people to not feel like they can never go back to a system, because one bad experience could be just that. So great question.